Mrs. Palmer, roll call, please.
Yeah.
Here. Here.
Here.
Here. Here. Residents and taxpayers of the borough are permitted to comment on current matters of concern or agenda items which are before council this evening. If you would like to address Borough Council this evening, we ask that you will please stand at the microphone, give your name, spell your last name, and give your address so you will be properly identified for the minute record. Each speaker will be limited to 5 minutes. As an alternative, written comments can be submitted to the borough prior to 12 noon Eastern time today. In that regard, we had four comments submitted via email. The first was from Carol Hess of what was her address? The King Ridge Road, questioning and discussing the issues around the fireworks ordinance. The next one was from Ann Fetterman with a letter of the same concern, again discussing the requirements associated with timing on the borough fireworks ordinance. A third one was received from Carrie Cannon regarding the same thing, proposed fireworks ordinance. And a final one along the same lines was received from Reuben and Megan Clark expressing concern of the timing constraints surrounding the fireworks ordinance. Max, you want to comment on those very briefly in the standpoint of what we've considered? And
Certainly. Yes, it was able to review these quickly. There were concerns about the 1 a.m. time period for some of the holidays, 4th of July, and New Year's Eve, and some other requirements. Unfortunately, under Act 674 of 2022, the state is very specific and has said that municipalities, although we may regulate consumer fireworks and display fireworks, we cannot have any regulations with respect to consumer fireworks on those particular dates and on the specific times that are listed in our ordinance. So unfortunately, that is not something that we can deviate from or change as commented. And this is a creature of the General Assembly and their legislation that they passed, giving some power back to municipalities to regulate fireworks. But they did put limitations and restrictions, and the times and dates that they've identified in the public comments are straight out of the statute.
all right, it seems that most of those who have registered to speak this evening are regarding the Yokas property, and that will be part of the public hearing. So we're going to wait till we get to that point before you speak. The only exception to that is a Mrs. Johnson regarding from Alden Drive.
Well, if that's about the Cardinal Ridge, they don't have a public hearing. So it'd be best if you go right now. Yep.
Go ahead.
Don't mind me just a moment.
Take your time.
Good evening again. First of all, thank you for the second opportunity to allow me to speak this evening in front of council regarding the water concerns relating to the Cardinal Ridge Townhouse plan. To begin, I'm sorry. Oh, I'm sorry. Amy Johnston, 2560 Alden Drive, 15143. Begin, let it be known that I do not intend to deny any person to their right to purchase land or build. In regards to water, although it may be true that water from the proposed housing plan would be less than I have now, It will be a continuous flow with an X amount of water being released over a determined amount of time, without allowing the natural dry time for the water to dry from one release to the next. The water will be retained, resulting in a wet and damp yard. The question is, why is the water being run into my yard? Simple. Stream. Under ordinance number 6552019 F, section 5 on page 5, it reads, and of course, I just lost my little thing, so. Stormwater flows onto adjacent downstream property. I'm sorry, I feel like an idiot because I just lost my little point. But anyways, I'll come back to that. If I can find it, it's on page 5. So of course I should be able to find it. There it is. The stormwater management system shall not create an adverse impact on stormwater quantity or quality in either upstream or downstream areas. Offsite areas with discharge onto and across a site proposed for development shall be addressed in the stormwater management plan prepared for the development. No stormwater management plan shall be improved until it is demonstrated that the runoff from the project shall not adversely impact downstream areas. Based on the proposed plan, my property will be adversely impacted by the runoff since I'm in that downstream area. Last month, I also asked if it was the opinion of the borough engineer that my property would not be endangered due to the grading and the runoff. Under ordinance number 167-2014, Article 1, 124-4A, under the denial of the permit, it says, when in the opinion of the borough engineer, the grading as proposed by the applicant is likely to endanger any property, person, or street, or create hazardous conditions, the borough engineer shall recommend that the borough deny the grading permit. In determining whether the proposed grading is likely to endanger any property, person, or streets, or create hazardous conditions, the borough engineer shall give due consideration to pertinent factors, including but not limited to possible saturations by rains, earth movements, runoff surface waters, and subsurface conditions such as stratification and faulting of rock, aquifer springs, and the nature of the type of soil or rock, both during grading and other completion of grading. I would like to know what his findings were to justify an opinion, if there was one on this. Finally, my points to ponder. You know, we've asked about, I think it's Mr. Wu, and why they can't go through there. No. So why can't we as a community say no? Still concerned about no traffic study. I'm concerned for the safety of the community. There's still a concern, especially for school traffic, winter conditions, which was horrible that a week ago. And of course, emergency vehicles with our streets not being wide enough. Why can't the SWM plan take the water down and under Alden Drive? That's what's proposed in motion 3 this evening. A similar SWM plan has been proposed for the medical office. Last thought, you know, how many developments in our Franklin Park borough has there been that allowed water from another building or development to run into another property owner's yard? And to close, as stated on your website under Borough Council responsibilities, it states, Borough Council establishes policies and regulations in order to maintain the health, safety, and welfare of its residents. And I'm a resident. And just as a side note, with water being wet and not drying out, with a constant wet yard, I could have pest infestation such as mosquitoes, fleas, grubs, leaf jackets, which are maggots, termites, carpenter ants, fungal diseases, weeds, soil erosion, nutrient deficient grass, ineffective lawn treatment. So even if I wanted to do a little garden, I may not even be able to do that if this water would cause these effects to my yard. Thank you very much.
Thank you, Mrs. Johnson. That's it. Okay, the balance seemed to be for the Okas property. So the minutes of the January 18th, 2023 pre-meeting, the January 18th, 2023 regular meeting, and the February 1st, 2023 work session minutes were given to mayor and council. Are there any additions or corrections?
Oh.
Says Washington Lane residents, not a specific person.
Okay.
It just says law person.
There is an entry here called Washington Lane residents. Is there someone wishing to speak? Okay, I see 4 hands. Would someone like to speak?
So there's actually 5 of us, all basically saying the same thing. Mine might go over a little over 5 minutes, but it will not take more than 25 minutes. So we're all speaking. So 3510 Beth Weibel, 3510 Washington Lane, Pittsburgh 15237. The Washington Lane residents continue to be concerned regarding the safety of those who use our lane, and especially those who are not aware of the hazard that was created along the beginning of our private lane. Our gravel lane is narrow, and in most places, it does not allow for much space for 2 vehicles to pass. Because of this, vehicles move to the grass area of the lanes right away, allowing for the opposing vehicle to proceed. This happens along the entire length of our roadway. It has never created a safety issue until the developer excavated this 26-foot drop off along the beginning of our lane. We've come before Borough Council numerous times stating our concerns. We've attended many Borough Council and Planning Commission meetings, either in person or via Zoom. We've written letters, hired an attorney, and had a survey done of our lane. We've asked numerous questions, usually not getting many answers. We've collectively spent close to $15,000 of our own money, and yet we are no closer to a resolution than we were when this started back in October of 2019. So we have some questions for the Borough Council. Are we getting any closer to having a guide rail installed? We provided the borough with the results of the survey that we had done last spring. We also invited the borough out to see where the stakes are along our right of way. The survey shows that not only does the excavation start directly on the lane's right of way, but also encroaches within the right of way. Why wasn't the developer required to have the 3-foot setback before excavating? Question number 2, after excavating the 26-foot drop off directly adjacent to our lane's right of way, the borough had the developer install temporary orange plastic construction fencing along the hillside. While that never would stop a vehicle from going over the hillside, it would alert a driver to the hazard. That orange fencing is now starting to fall apart. What's going to happen when that's no longer there? We've heard that someone besides the Washington Lane residents and the Bliss developers have done a survey on the lanes right away. Is this correct? We have not received it if it is. Because the extensive excavation that was done directly next to and on our lanes right away, who is responsible if that area would start to landslide? Question number 5. Who is responsible if somebody would go over the hillside? This is a developer created steep hillside excavated directly on a road right away. Number 6, a Franklin Park ordinance under standards for excavation requires a developer to notify adjacent property owners that excavation is going to begin. We never received this notification. We have asked a few times previously about this. Was anything ever done? Our lane does have a 40-foot right of way. We thought for the safety of all those that use our lane, we would shift our gravel cartway and use a part of the large unused portion of the right of way on the Brant side of Washington Lane. Following the advice of the borough solicitor, we again sought out our own legal advice on how to proceed with the next step. The lawyer researched our properties, including the Brants. The Brants' deeded property does not include the Washington Lane right of way. Shifting our lane over would not affect any of the Brants' deeded property. As previously stated, we have already had a survey done of the Bliss and Brant portion of Washington Lane's right of way. We know where this line is. The Brants ended up hiring their own lawyer, Christina Malkin, from the Franklin Park Planning Commission. Though she didn't disclose this information to our lawyer, we recognized Ms. Malkin's name from whenever we attended many of the borough meetings. We have negotiated for approximately 8 months and have not come any closer to a resolution. Our next step would be going to court. That's expensive. In the meantime, we've asked again for any of the obstacles that the Brants have placed directly adjacent to the gravel cartway to be removed. These are blocking the use of the lanes right away. As previously stated, our gravel cartway is narrow and does not allow much space for vehicles to pass. We do not want vehicles to move over to the Bliss side and potentially get injured on this steep drop off. To date, these obstacles have not been removed. So we have some questions to contemplate. Does living on a private lane in Franklin Park mean that we should have our own lawyers and engineers? Question number 2, we pay the borough taxes just like all other Franklin Park residences. We do our own road maintenance and snow removal. We know that's our responsibility of being a homeowner on a private lane. Should we also be required to spend thousands and thousands of dollars to fix an issue that was created by a developer and approved by the borough?
Ms. Weibel, that's your 5 minutes, and we know you have other people that can continue from where you left off.
Ready? Donna Skundridge, 3512 Washington Lane. Number 3, just because a developer chooses to excavate a 26-foot drop off directly on our lanes right away, does that then make us private lane residents responsible for that hazard? Because the Planning Commission, the Borough Council approved this plan, doesn't that make the borough liable? Number 5, back in the spring and summer of 2019, during the initial Bliss plan, the Planning Commission did not require the developer to tell Washington Lane residents of their intentions to take over the beginning of our private lane, make it public, and to use it as the entrance of their development. The borough solicitor had advised them to notify us. Instead, the Planning Commission recommended approval to this plan. Why wouldn't they have notified us? Number 6, why are we, the Washington Lane residents, being made to pay not only financially, but also with potentially our safety because of others' mistakes and oversights? Why are developers allowed to adversely affect current residents' safety? Number 8, the Washington Lane residents have not created this mess. Our lane has been in existence for 80 years and has never had any safety issues. Thank you.
Thank you. Any other comments for Washington Lane? Thank you. No.
Casey Munch, 3509 Washington Lane, 15237. I just don't understand how developers can come in and cut a hillside like that right up against our private road and risk our safety and not do anything about it. Because now that every time I leave the driveway in bad weather, I have to fear that I'm going to slip and I'm going to end up in that development rolled over in my truck. Even with the water retention down there, the dirt's not packed in. What if our road caves over? Those are my concerns. Thank you.
Thank you. Okay. Any other comments for Washington Lane residents? The minutes, let's see, I did do that. Treasurer's financial report.
Thank you, Mr. President. General fund revenues for the month of January totaled $455,547. Year-to-date total revenues are the same. It represents about 4.1% of the 2023 total budget. Conversely, our general fund expenditures for the month of January totaled $758,562. It's also the year-to-date total expenditures. That represents approximately 5.9% of the total 2023 budget. That concludes my report, Mr. President.
Thank you, Mr.
It is read.
Second. Any discussion? All in favor?
Aye.
Opposed? Motion passes. And we need to back up. We need a motion for the minutes of the January meetings.
Move the minutes of the January 18, 2023 pre-meeting and then January 18, 2023 regular meeting and the February 1st, 2023 work session be approved.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carries. Mayor O'Keefe, would you give us a police report?
Yes, thank you, Mr. President. For the month of January, the Franklin Park Police had 683 calls for service that resulted in 10 arrests, 2 underage drinking, 3 access device fraud, 3 DUI, and 2 animal neglect. There were 73 citations and 234 warnings issued. We had 1 special response team call out for Brackenridge. Chief Healy and Lieutenant Snyder place high priority on training. Officers attend in-service courses offered by the Municipal Police Officers Education and Training Commission. Currently, we are focused on 3 commission courses. Legal update highlights pertinent court decisions and significant pieces of legislation that affect police operations and investigations. Tactical communications helps officers recognize and identify components of a risk event. Lessons focus on officer responses that help initiate safe resolution and de-escalation of aggressive action. And unfortunately, sadly, another police officer has fallen, as you have heard, I'm sure, McKeesport officer Sean Soglansky. Franklin Park Police honored him by their attendance. Yesterday at his funeral, we had 2 police vehicles there and also 6 officers. And condolences to his family and everybody that loved him. And that completes the police report, Mr. President.
Thank you, Mayor.
Recommend the police report be filed with the police secretary.
We have the fire report, Mr. Mizlinski.
Yes, Mr. President, the fire company responded to 22 fire calls in the month of January, which included the following: 7 fire alarm system activations with no fire, 4 dispatched and canceled en route, 4 vehicle accidents with cleanup and traffic control, 2 no incident found at the given location, 2 CO alarms with CO readings, 1 shed fire where the shed was destroyed, 1 smoke scare or odor smoke, and 1 natural gas leak. We were assisted by other fire companies twice, and we assisted other fire companies 3 times. Year-to-date fire calls were 22. For the month of January, the fire company expended 466 volunteer man hours. End of report, Mr. President.
Thank you, Mr. Mizlinski. Builder inspectors report, Mr. Phillips.
President. Construction report for January 2023, 11 permits were issued for the month, 1 single-family dwelling, 1 remodeling, 1 deck, 1 commercial occupancy, 1 demolition permit for a house, 6 miscellaneous permits. Total valuation of construction for the month was $650,948. Total fees collected for the month were $8,456. End of report, Mr. President.
Thank you, Mr. Phillips. Borough Council held an executive session on February 1, 2023 to discuss personnel matters, the Yokas quasi judicial deliberations, Washington Lane pending litigation, and Carriage Lane potential litigation. This evening, we held an executive session concerning potential litigation of Cardinal Ridge. Old business. Mr. Yunker, would you like to continue public hearing conditional use application number CU 22-12-05?
Certainly, we'll go on the record now. This is the continued date, time and location for the conditional use application CU 22-12-05. The application by David Yokas for approval of a medical office use on the property located at 2568 Wexford Main Road. Welcome back, everybody who was here in January, and I think we have some new faces as well. But briefly, to reorient members of council and the public, the applicant did put on their case in chief. There was an issue with a requirement in the ordinance regarding conceptual plans or construction plans being submitted with an application for a modification or renovation of an existing building. So that was one of the reasons why the continuance was made until tonight. There was also questions about the sewer line and MTSA and statements that the applicant would look into that some more. So we might hear about that as well. We did grant party status to 5 individuals that live in close proximity. Those were Frank Guzik, Nick Barone, Derry Gross, Pat Foltz, Michelle Connolly. They were permitted to ask questions of the applicant as well as give their own statement during that public hearing. The one thing that I neglected to say at the close of the public hearing or the continuance of the public hearing last month is that once a public hearing has started, essentially a curtain comes down, that there can be no conversations by members of council that are sitting in a quasi judicial stature with the applicant or with any parties or other individuals interested in the application. So we typically make that announcement to say, don't reach out and contact. If anybody did send an email or run into a council member on the street and got a cold shoulder or were ignored, they were not being rude. That is the general direction and the direction I've given council with respect to this public hearing and all others when we're dealing with a conditional use. So no, that was not rudeness. That is a requirement of the Pennsylvania Municipalities Planning Code. We do have a number of individuals who have signed up. It looks like some are from last meeting as well. Before we hear from the applicant and review the conceptual plans that have been presented, I'll once again ask, is anybody seeking party status in this public hearing through which they may ask questions, cross-examine witnesses, be cross-examined themselves, or otherwise participate as a party in tonight's public hearing? You could also be involved in any appeals or litigation resulting from the decision by council. If you don't wish to take party status, we will give an opportunity, if the public hearing is closing tonight, to hear public comment limited to 5 minutes each, as we did at the outset of the meeting. If you do want to give any public comment on the record and before we take action on this application. Is there anybody that is seeking party status that did not seek party status at the January regular meeting? Anyone, please come up and state your name, please, and your address and your interest in the application.
Kelly Simpson, SIMPSON, address 2413 Rustic Ridge Drive. 15143. Is this when I should speak my?
No,
Okay.
just in terms of your location, your proximity and your interest in the application. I don't see Mr. Lope here this evening. Is oh, okay. Mr. Castor, any objection to party status? No, hearing none.
Okay, thank you.
Thank you. Yes, next.
Linda Guzik, Guzek, 2566B Wexford Bain Road. I live next door and I have some questions.
Okay, thank you. And any objections? Hearing none. Okay. Yes. Okay. Can you identify yourself just briefly for the purpose of the record? Okay, thank you. So we'll don't need to swear you in or do anything else of that nature. Anybody else seeking party status? Seeing none. At this time, I will ask that we swear in our 2 new party witnesses and that the other individuals that spoke at the last meeting reaffirm their swearing in if they speak again tonight. Kelly? Thank you. All right, with those preliminary matters out of the way, we did introduce a number of exhibits at the last public hearing. I think we ended on exhibit J, Mr. Phillips' staff report. But I will now turn the floor over to the applicant to review their additional submission.
Good evening. My name is Stephen Victor from Victor Wetzel Associates. I was here last month with Phil Lope in his absence tonight. His partner, Stephen Casker, is here. I'm also joined by the applicant, David Yokas. The close of last hearing, we said that we would work toward preparing the documents that are required for identifying the scale, character of the building. And so this would be, I guess, our exhibit number K. That'd be correct?
Well, I mean, those were all borough exhibits. I'm not sure, Steve, did you introduce your PowerPoint presentation?
Not, then let's
Yeah, we'll
call
still call
that
that.
number one,
Mhm.
and well, this will be number two.
Correct.
That will work for you. And so I'll just quickly go through the drawings that we have prepared. I have, and I know it was just today, but I have put a letter out to Tim asking if these drawings were adequate or if additional drawings and information would be needed. And if it will be, we'd be happy to have our architect continue on. I just received his drawings this morning, so he has been working on it up to this point, and he's happy to continue on if you need additional information. There's 4 drawings. The elevation shows the front elevation of the building. Front green siding was there, and used a combination of brick and stucco materials on the exterior of the building. And obviously, we're looking at the front door area, looking at the first floor and second floor. The floor plan is essentially because of the office places in which the individual tenants can finish it out for their own needs. From the front door, we have a central hallway, elevator to get to the basement and the floor, second floor. And the ladies' restroom, second stair tower, and then as we described it previously, on the right and left side would be 2 doctor suites. On the second floor, a similar footplate, elevator, 2 sets of steps, and then the bathrooms. Again, on the right and the left side, 2 doctor suites. 2A and 2B. As we have shown on the site plan, we have our basement area. We're able to utilize that for underground parking, and so the architect has demonstrated through the garage door that's shown on the site plan how it is possible to install 12 parking spaces on here. Access from the basement to the stair tower for the elevator itself. And the parking, as we described it, is solely for the use of the doctors and staff within the building itself. The front parking lot, the patients, the rear parking lot, the door for the staff. I believe previously we have demonstrated in the last public hearing our compliance with the conditional use standards, and hoping that this is enough information for you to be able to make your decision on this application. Again, if additional information is needed, be happy to do a continuation and provide that to you. Thank you.
Thank you, Mr. Victor. Yes, I mean, in terms of, you heard the announcement that we did have a discussion in executive session at the work session. At that point, I think there was a request of perhaps not being able to get this together in time and perhaps continuing until March, but we appreciate that it was put together and that we are able to meet tonight. I think, are there any questions from members of council reviewing these? Once again, as we talked about before, the ordinance does not require building code plans, does not require a land development plan at this level. That will be required later. Obviously, a building permit will be needed in the future. And I was trying to find the actual language, but my computer is bouncing around in terms of the requirements, but it is to give a concept or a conceptual idea of what a proposed conditional use will look like when a building is proposed to be renovated. Mr. Schwartzmeyer, I saw your hand. We'll start at that end instead of this end.
That's okay. Just a very brief question. In the parking level down in the basement, is the leftmost bay unexcavated or unused?
Yes, sir.
Okay,
It's-
that's
it-
what I assumed.
In the original plan, that was the garage area on the first floor.
I got you.
And so that's why it's an unexcavated basement.
Okay,
Or
thank you.
no
All
basement underneath it. Yes, sir.
right, thank you.
Dr. Lee? Nothing. Ms. Linsky?
No,
Nothing?
thank you.
Parks?
I'm good at this point.
Mr. Malkin? Khaled?
Yeah, just going back, thanks for providing this information. What is the sewer plan? Is there any more movement in that since the last month when you presented?
We have done some research on that. I think the certainty of being able to go the route that we talked about last time is still a variable in that we did not get anything definitive from PennDOT as to whether we could use the rights of way and how we could get there. We have had discussions with the Sanitary Sewer Authority. I think what I can say with confidence is that we do have an easement for a gravity sewer through the Catholic Church property. If we are unable to use the Rustic Ridge access, which would be preferable because of its it's the shortest of the two routes, but failing to get the appropriate PennDOT permits, that we then would fall back and go through the church property where we already have an easement.
That would not require the pump then.
Sorry?
That would not require you to use the pump then.
Correct. It is a gravity line all the way through the church property. It was one of the comments that we got from MTSA, that they would prefer to see gravity. They don't have a prohibition against using the pumps, but their preference would be the gravity.
I do have one quick question. Any change in the timeline that we had talked about at the last meeting, that through the process of this will be about 2 years before it's ready?
I think that it's probably more like 18 months. I think the real timeline was the one in which we must come back and complete our land development process. And then from there, then it's just the remodeling time. So that may be as short as 12 months, but I think to be safe, we should once we have land development approval. So I think that if we wanted to be conservative, we could say it's very easy to be completed in 24 months. Yes, sir.
Max, could you just briefly kind of describe the land development approval process just for everyone?
Sure. Because this was originally proposed as a single family residence, a single family residence does not go through a land development process. Now that it's being proposed to be the medical office, it's a non-residential building. So it does require land development approval, which means essentially a land development plan showing the details like that connection to the sanitary sewage, the stormwater controls, the required parking, the lighting requirements, everything that we set forth in our subdivision and land development ordinance needs to be addressed in preliminary and final plans. It goes through a review process in front of Planning Commission for almost 90 days or so, and can be subject to review by the borough engineer, the cost of the applicant, as well as the borough solicitor at the cost of the applicant, and then gets finalized. And if the plan meets the terms of the ordinance, it can be approved by Borough Council. At that point, one of the conditions in Tim's staff report is typically the requirement for a development agreement. We have a standard form development agreement. It sets certain requirements in place. This will require a performance bond in the amount of the required improvements from our ordinance. So not so much the renovation of the building, but any impervious surface, any site work, stormwater controls, et cetera, that will need to be installed and inspected by the borough engineer, make sure they comply with the plans before those funds are released. And because this does not involve any public infrastructure, there would be no acceptance or dedication or acceptance of any infrastructure that would become the borough's responsibility in the future. So that is our typical development process that we go through every month.
Thank you.
Yes.
Yes, just to piggyback off Mr. President's question about the timeline, do you have a project plan? I mean, is this something you've done before? The reason I'm asking is there's a lot of disruption that can occur with construction vehicles going in and out. Have you detailed this out in terms of milestones or anything?
No, but it's quite honestly, it's a very simple project. The portion going through the borough and preparing the application for the final land development process and going before your planning commission and yourselves for that approval. We anticipate that's the 6 months. And following that, then it's pretty simple. You just apply for a building permit, you get the building permit. The structure is already up. The site's pretty well graded out. So there's not a bunch of site work for it. This is not a complicated project. This is going to be simpler than building a large single family house.
Okay, I understand. And in terms of funding, is there any committed funding for this? It's bonded. I mean, I'm trying to prevent projects that are going forward that are not funded and they stop in the middle and they take 10 years to complete. I mean, that building has been sitting there for 20 years.
We are prepared to accept the financial responsibilities, including the bonding, as necessary to see this project through. If we're going to spend the money to go through the land development process, we're not going to just throw that away to then say, oh, by the way, we ran out of money. No, we're prepared.
Okay, and I think in the past you mentioned you have tenants lined up, committed leases or.
We have commitments for tenants. Yes, sir.
Good for now.
Yes.
I have a couple of questions. How many tenants do you have?
Or
Last month, you said there was a reconstructive surgery in the tenant.
yes,
That's
There would-
changed. I just wanna-
those would be two of
Friendly,
those are two of the tenants. Yes, sir.
so four tenants,
Yes.
max. Would you-
Well,
would you-
let me. Well, we have 4 suites. One doctor could come in and say, oh, I only want half a suite, and then one doctor could take another half. That is possible, but it wouldn't increase the overall doctor loading or that because it's,
You're not planning on 5 or 6?
No.
Would your applicant be adverse to committing to ground level dark sky lighting on the site?
yes. No, we would
You would
agree.
commit to that?
You asked if we would commit.
Okay.
We have no problem at all with
As a
dark sky.
condition,
Sure.
What about providing for 100% screening at 6 foot and 8 along the required side yard to the west and along the rear property?
Yes, we agree to that. That is, I think that's a code requirement anyway, but we'd be happy to,
Well, I'm talking fence.
yes, 6 foot solid fence. I don't see that as a problem.
I think that would eliminate some of the concerns that we had last month.
Both to the west and south of us, there are single family residents and sure, that's appropriate.
Mr. Phillips? All right, no other questions from council on the 2 issues that we have in terms of the conceptual plan and the sewer plan. Before we get to people that have signed up, I'll offer either Mr. Guzek, Mr. Barone, Ms. Gross, Ms. Foltz, Ms. Connolly, Ms. Simpson, or Ms. Guzek, if you have anything specifically related to what has just been presented. You may ask a directed question as to that. If you want to talk in general about the overall plan, we'll give you that time as well. But just wanted to give people the opportunity to ask any questions about what has been specifically presented this evening, if they're a party. Ma'am? Yes, and you as well, Mr. Melo.
Could you step up to the microphone?
Yeah, that's-
Thank you. My name is Lawrence Madelon, here on behalf of Michelle and Ned Conley, as well as the Rustic Ridge neighborhood. And so I'd like a little bit more information about the sewer that you were talking about. You do not have an agreement in place right now with MTSA to connect to their line in Rustic Ridge. Is that accurate?
That is accurate, but also, we don't need to have one at this point in time. We will have to have that, when we initiate the land development process through a planning model.
The reason you need to have a conversation, though, and I'm just catching up to speed on this, is that there is not a main line running down 910 that's adjacent to that property that you could just tie in directly. Is that true?
Yes.
Okay. And so you're looking at options as to how to provide sanitary sewer service, but at this moment, you have nothing confirmed.
We have something. We have a right of way through the Catholic Church property to construct a gravity sewer. That is confirmed.
When you say it's confirmed, so you have a right of way for access with the church, correct?
Yes.
Is that going to be a private lateral?
No, it'd be a main line.
Okay, so it's your understanding that then MTSA would accept that line.
Yes.
Okay.
We've been in discussions with MTSA.
You have a development agreement in place and signed from MTSA indicating that they would accept that line if it's constructed.
And your agreement do not.
Now, would you agree with me, though, that that is the process of a sanitary authority? That if you're going to construct a line that they're going to accept, they will require you to sign a development agreement. True or false?
It is at the appropriate time.
And that, and part of that is for you to provide them a design that they're agreeable to in order for them to grant that right for you to build that line on their behalf. Correct?
Yes.
Okay. So at this point, you've had conversations, but the document that is relevant or that you could present to this board to say, we are confident that there will be no issues with MTSA. You do not have that in hand.
That is not a condition. Requirement for
That wasn't my
initiation.
question.
It is my answer though, to you that there is no requirement for us to certify where our sanitary sewers are. We are stating through the public record that we have an easement through there that will meet the standards of MTSA. And we've had discussions and dialogue with Ray All, who runs the sanitary authority, that what we are doing is correct.
I thought Bill Youngblood was the executive director, but
He is not.
he's not? Yeah.
He's Bill Youngblood, maybe like president of the authority, day-to-day operation, or Ray.
So I look at section 212, 1803, general standards and criteria for conditional use. And you presented in front of the planning commission, made a statement as to how you meet that criteria. In section 7 of that ordinance says the proposed use complies with all applicable standards and requirements for providing sanitary sewage disposal, water supply, stormwater management, solid and toxic waste, and storage disposal. So right now there's a septic tank.
Yes.
On the property. And you,
Well. Yes. That's there.
and the commercial building that you're proposing, the medical office, you're not permitted to use the current sewage disposal system on the property for that.
Nobody is told can do it.
Well,
That would be regulated by allocation.
well, I think we'll work on the assumption that you can't, or you would have been doing this work to spend the money to put in the sewer, right?
Yes, sir.
Okay. So it's reasonable to assume you can't. Yes or no?
Yes.
So this provision I just read to you clearly state that you have to have something in place to provide for sanitary sewer disposal. And you've testified as of now, all you have is an easement from the church.
And
A verbal conversation, but you agreed with me that ultimately you need a development agreement signed actually do the work and for them to accept it, because you have to do it in accordance to their standards. You don't have a development agreement now, do you? Okay, so this criteria, you don't meet that criteria other than via a verbal conversation. Agreed?
No.
No? How do you
No.
meet it then?
Standard, just like this building. We're not required to come in with construction drawing. It's just like the site plan, not required to come in with construction drawing. Like, we're here to talk about meeting the condition of this section of the ordinance allows for professional office in the R4 zoning district. And we did that. And we believe that with the testimony we're giving you, we have access to sanitary sewer.
Well, I know the board doesn't want to hear us dicker back and forth, but I'm going to make a statement or take the position that the board consider section 212-1803, subparagraph A7, and that the opposition's position that they have nothing in writing other than a verbal conversation that satisfies the obligation that they have sanitary sewage disposal accounted for and in place.
And it's your position that you need to do all of that before you're granted conditional use?
I think our position is you have to provide reasonable proof
Right.
that you actually have that. And conversations with MTSA are not sufficient. A developer can get a utility rights letter from an electric company or a gas company that they're going to have access. They easily could have gotten something from MTSA to say that, yes, we're agreeable that we're going to accept. That's a long lateral that they have to accept. And I represent sanitary authority, and you probably represent some yourself. They don't like that, okay? And they look very closely at what the development spec is. It's my understanding that this lateral runs on a slope that's going to significantly disturb the vegetation of the Rustic Ridge neighbors. So we're going to go in there with a backhoe and a dozer and clear out everything along this easement that the church gave, further disturbing the neighborhood and the environment. And the applicant is asking the board to take it on good faith that they'll be able to cut a deal with MTSA. And I don't think they've presented sufficient evidence to meet their criteria.
And I understand, I mean, in terms of a third-party permit is what we're talking about here. That's comes up all the time, NDOT, HOPs, everything else. We'll definitely take into consideration your argument. But I think in terms of this particular issue, it's something to consider, but it's not anything we've ever imposed on a conditional use applicant. If he can't get sewage, that building as designed here can't be built, and we still have a pending condemnation order that's out there because there hasn't been work being done on this work for some time, and that's where we would end up.
But the only other point I would make is that we have a lot more confidence or comfort if there was the MTSA main was running down 910 and all they had to do was tap it.
Oh, I don't disagree with that. That's why Mr. Phillips brought it up last month and brought it up before, and I think brought it up when Mr. Yocas was looking at purchasing this property, that sewage is an issue there. There are potential solutions, but none of them are inexpensive.
Do you have a plan that shows where the line will run through the easement that you could produce at some point? I'd make a request that be produced to council. One other question, or one or two other questions. You indicated that there were commitments from tenants. So have they signed leases, conditional leases? Well, what is the commitment that you're aware of? Okay, so your understanding is you don't know what the details are. You don't know if it's verbal. You don't know if it's a hope and a prayer, but there's commitments.
Yes.
Okay.
It's not a candidate requirement.
I'm not saying it is. I'm just saying you testified to commitments, and obviously there's a concern with respect to this particular applicant and the history and ability to complete the project, which adds another level, I think, of complexity to the review process. It's not as if we're dealing with someone who has a history of development, at least in this area. I don't know your applicant. He may have significant history of development. But I do know that that building's been there since 2007 and nothing's happened, so.
And Mr. Mayor, yeah, we'll give you time to
Okay,
give a
okay,
summation, but if we have questions, we can ask them. Thank you. Thank you.
And it has to be a main line, because commercial must tap into the main line, they can't run a ladder at that point. So, you know, 2,000 feet. Not relevant, our cost.
Okay, thank you, Mr. Mailer. Thank you, Mr. Victor. At this time, we'll open the floor for public comments. If you want to come up, we will go in the order in which people have signed up. We will limit you to 5 minutes, but you will be recorded by our stenographer, so please speak slowly. And I will say that, you know, this portion, other than the people that were sworn in as parties, we're not going to swear in anybody else. If you just want to give public comment at this point of the public hearing. Yes. Yes, well, and we'll ask both the applicant and Mr. Mailer to give a closing argument of sorts. So first we have R. John Sipple. Oh, you need to.
I don't even know. They answered pretty much all the questions I had.
Okay. Thank. 24. Yeah, I can read them. 2428 Rustic Ridge. Thank you. Next is Douglas Sipple at 2412 Rustic Ridge. Okay, I like that. All right. Linda Guzik at 2566B Wexford Main Road. Previously sworn in.
Okay. I have actually a question about the drawing. I see the parking lots and I see all of that. But we have water that has come across our properties since the development of this property. When we first moved in, we didn't have 2 inches of water every time we had a storm. Now we have at least 2 inches of water on our property. So I want to know what's going to be done to mitigate that, as well as what's going to, rainwater, the lights, and also the landslides that are occurring now since they have changed the landscape. Because we have trees coming down on our property from that property right now.
And this is a difficult part of a conditional use hearing for the future use of this property.
Right.
You know, the current conditions.
Well,
that
it's
we
still, but,
encourage you to talk with Mr. Yokas. He's here.
right, but I understand that, but with the parking lot, that's going to provide more storm water,
Correct.
and therefore it will damage my property further.
Well, that's the beauty of land development and stormwater controls that, you know, this
Okay.
building, which was incomplete and had, you know, I don't think it had a roof leaders hooked in or anything like that, will need to be controlled. There was some testimony at the first hearing about just the preliminary plan to store that and release it at a rate, but at the land development standpoint is when that becomes the issue.
Thank you.
Thank you. Next, Francis Guzik at 2566B Wexford Main Road. Hello again.
Francis Guzek, Guzek, 2566B Wexford Main Road. I'm going to start off by reading a definition out of 212-202. Medical office clinic, a building used exclusively by physicians, dentists, or other medical personnel for the treatment and examination of patients solely on a outpatient basis, provided that no overnight patient shall be kept on the premises. Okay, now I'm going to go to 212 attachment. It's either 1 or I. Table 4.4, medical office, R4, conditional. Says singular, not multiple. Table 4.5, medical and diagnostic lab outpatient, medical office / clinic, R4, not permitted. Now I'm going to go to some word usage I have here. Okay, word usage, part B, number 3, that's a 212201. Words used in the singular number shall, which is mandatory, include the plural and the plural the singular unless the context indicates clearly to the contrary. Now, the reason I go there is I'm going to go to, let me see, where do I want to go? Okay, this is zoned R4 and under usage, okay, what it has to be is under use, B, use principle, the main use of the lot. Being as it is in R4, the main use of the lot should be residential. Okay. Now, if that's the case, which it should be, the accessory use of a residency involving the conduct of an art or profession, the offering of a service, the conduct of business, or the production of handicrafts on a residential site. This use is incidental and secondary to the use of the dwelling for the residential purpose and shall not change the character of the residential use or adamantly affect the use permitted in the residential district. So what that's telling me is that we are zoned R4. This building is going to be commercial. A couple years ago, this board turned down the spot landing, the spot location of commercial. So why are we changing it now by calling this building commercial, but not the property? So we got a conundrum here. I'm tired of looking at this place. I'm tired of the problems with it. I'm tired of it because I had to deal with the moron that built it, okay? And the borough made a mistake. I don't know what kind of permit you gave him, but it was a big mistake. He should have had a time limit. This building should have been completed at least 15 years ago. Okay, so apparently the borough made a mistake. What I'm telling you is no matter how you dress this up, it's a commercial building and you're turning an R4 lot into a commercial lot. That is not allowed in Franklin Park. And the reason for a medical office and or a doctor office is years ago when we didn't have EMS, emergency medical services, hospitals handy, doctor's offices handy. Doctors were allowed to put an office in their home. Architects were allowed to put an office in their home. Not offices, office. This is offices. So I think we're in a problem here and I feel for Dave. He's trying to recoup. But if you pass this, you're literally spot zoning this commercial. And you turned it down a couple of years ago. Thank you. Any questions?
Yep, thank you, Mr. Guzik. We discussed at the last meeting that was the zoning hearing board. It was a request for a use variance for a professional office. This is a medical office, a conditional use, a home occupation is a separate conditional use, but thank you. I know we could debate. I didn't convince you last month and I won't convince you now, so we'll move on to the next ones. Well, but that's how zoning works. Greg Simpson, 2413 Rustic Ridge Drive. Good, okay. Kelly Simpson, 2413 Rustic Ridge Drive. Previously sworn.
I would like to start by asking council if this is approved, what protections are in place to make sure the owner of this medical building adheres to the regulations of the conditional use? What happens if in 1, 2, 3, 4 years, they allow a non-medical tenant to occupy this space? Who will govern this and what repercussions are there if the owner breaks the rules at any time in the future? Medical use is extremely broad in scope. What safety protections are in place regarding the type of medical professionals that are permitted with this conditional use to ensure that we don't have unreputable practices such as medical marijuana dispensaries, methadone, or other drug clinics next to our homes and nearby a school bus stop that may invite crime and violence into our neighborhoods? Mr. Yokas submitted a zone variance request in 2010 with a proposal for multiple business professional offices, which the board rightly denied. But his application dated 4/15/2010, Mr. Yokas stated, medical offices conditionally permitted, business or professional offices are not. However, they likely represent a less intense use of the property than medical offices. Has the board thought about how this intense usage stated by Mr. Yokas himself will impact our neighboring homes and communities? I would also like to point out M1, which is a mixed-use residential commercial zone within Franklin Park, which is located along Nicholson near 5 Points. This allows a mixture of low-intensity commercial and residential uses, but I quote, to reflect the existing small-town character associated with land use patterns. The offices in M1 must comply with residential aesthetic, yet we aren't provided those same protections within R4, R1, R4 residential zoning. In closing, we are concerned about our safety with no outline conditions in place for what falls under medical use. Allowing a medical service building in R4 zoning would disrupt the residential character of R4, and it does not specifically address an essential need for services within our community. Approving this request for conditional use without a need or service to the community, changing the residential nature of R4, is doing what is best for Mr. Yokas financially, not what is best for Franklin Park residents. As stated by Franklin Park Board Council on November 9th, 2021, Mr. Yokas, quote, I quote, Mr. Yokas made a bad investment. Now the residents of Rustic Ridge, Fox Chase, and the homes along this area of Route 910 will pay for it with possible degraded property values. We ask you to deny this request for conditional use and retain the residential character and safety in what is the only R4 area of our community. Thank you.
Thank you. We have Steve Kasker. We'll hear from you at the end. Amy Johnston was for the other one. Elizabeth Fry, 2409 Rustic Ridge Drive. Okay, I'm sorry. Thank you. Timothy K-A-U-K or Housick? V-I-C. 1500 Fox Chase Drive.
I'll make it brief. We won't need 5 minutes. One of the concerns that I have is, first of all, I'm a doctor, I'm a surgeon, and have been so for a long, long time, over 35 years. And I've participated in staying in medical office buildings at North Hills Hospital and other places. My concern is, do any of you seated up there believe that we need yet another medical office building there where this proposal is, when we have other buildings nearby that can be used for medical offices that already have all their plumbing and sewer, electrical, and so forth in place? I don't think we do. Now, for all the reasons that were already discussed here by several of the local residents, I don't think we need another medical office building. I wonder if any of you believe that we need one in that location. I don't think so. We have a lot of empty spaces in some of the buildings, both in front of, up to the west and also to the east on that same side of the road. And so I don't believe we need another medical office building in this location in the first place. Now, I'm not denying anybody's desire, if they own property, to do what they want to do on the property. That's, of course, Mr. Yokus's prerogative. But my point is, you don't need another medical office building at that location at this time. You just don't. And I don't think anybody could justify that. Thank you.
Thank you, Dr. Kavik. Next I have Julia Wu, 2038 Karen Drive. Okay, thank you. David, I'm sorry, I can't, nothing, okay. I could try DELFI and then a squiggly line. ANDRA. Next page, we have Jeff. Is it Mer? Oh, that's another one. Help me out there, John. Merkin? Yes, 2403 Rustic Ridge. Okay, thank you. I think that's everybody who has signed up. At this time, we'll hear from Mr. Malo and finish with the applicant.
Really like to talk about the deer in my yard.
Well,
I'm not gonna do that.
it's another name.
As already stated, I'm here on behalf of Rustic Ridge residents, and I've been engaged by Michelle and Ed Conley. I'll try to make it short. As a solicitor myself, I understand that you're required to comply with an ordinance. I understand that this is a conditional use. But I also believe that if you look at the section 212-1803 general standards and criteria that were defaulted to determine if this conditional use is appropriate, have not been satisfied. And it is the burden of the applicant to satisfy that criteria. I'd like to point in particular to section 1 of 212-1803. Actually, it's A1. And it says the proposed use will not alter the established character and use of the neighborhood or district in which is located, and will not impair the use or development of the adjacent properties. So I don't know if this map is already part of the record, but I'd like to make this map part of the record. I think it is very helpful in showing that this proposed medical office building is going to be located right in the middle of a residential area. The applicant admitted at the Planning Commission that it is on all four sides fronted by residential properties. So recognizing that the ordinance permits a medical use, we also have to look at the criteria that they're required to meet in order to have that approved. And this area is not an area where we're transitioning from office to multifamily to residential. And these folks who live in Rustic Ridge and who are adjacent to this property look out their window and they see multiple commercial buildings in the distance. It's all residential. On every side of this property is residential. And we're putting a commercial office building in a tight space in the middle of a residential development. And that does impair the value of those properties. There's no doubt that with a medical office building within 20 feet of your home, the value's gone down. And unfortunately, I came into this a little bit late, but if the record's remains open, we're going to produce evidence from a professional that it will reduce the value of the adjacent property. So in effect, that section A1 that I've cited, they're not meeting that criteria. Because of this location of the property, it is going to impact the value of these homes. You also look at section 4 of 1803, and we've heard some things about lighting requested and conditions, but that section talks about, and I'm not going to read the whole thing, but one of the things it indicates is, will illumination and glare impact adjacent properties or the neighbors? Again, if you look at the topography of the Rustic Ridge neighborhood and the properties that are directly adjacent to it, it doesn't matter what kind of lighting you have. When they sit out on their back porch at night, instead of seeing an unimpeded view, they're going to see light. And again, I don't care if it's dark night, whatever you want to call it, it's going to be a change in condition in a purely residential area. And that's the point that I want to continue to hit on. It is residential. It is not a mixed use location. I've already talked about subparagraph 7. I'm not going to belabor the point, but there has been no proof or satisfaction that they're going to be able to handle the sanitary sewer requirements for that site. It's currently septic, and we've heard that there were verbal conversations with MTSA. Well, if MTSA is going to have to accept a 2,000-foot main line, there are going to be a lot of conversations whether they're going to be willing to do that. And they don't have any obligation to do it. There is no obligation for that authority to say, yes, we will take that line. So in conclusion, with respect to whether they met the criteria or their burden of proof, I don't think they did. However, I understand that if they did meet the burden of proof as opposition, then it's our obligation to show that the use will detrimentally affect the health, safety, and welfare of the residents. Now, you've heard a number of statements made by residents, and I'm not going to belabor the point, but again, I'll state that the character of the neighborhood, and do we know if this is part
It
of?
is. That is part of the application that was included as initial Exhibit A.
The character of the neighborhood detailed in Exhibit A shows that this commercial medical use is right in the middle of a residential area. And so, again, I believe that meets the burden of being detrimental, the detrimental standard to the general welfare of the community at large. Additionally, what is very concerning to myself and the neighborhood is the history of this site. I think it's important that the board take into consideration what's happened over, the last since 2007, on multiple occasions. And if you look at I'm going to reference the Allegheny County Court of Common Pleas case filed at SA 22-168. And that record, and I'm not going to repeat it, obviously, because it's a matter of record and the judicial notice if this goes on appeal. But I would like to point out the history of the site and the history of this applicant. On October 2016, they were cited but for a violation. On January 14th, 2019, again, they were cited for a violation in connection with an expired building permit, and a complaint was filed on April 30th, 2019. 2 notices of violation were issued in June of 2020 for property maintenance issues, dangerous structure, premises, exterior walls. Incident reports with the police were of record in August 2nd of 2014 for unsecured building and theft, June 12th of 2019 illegal dumping, September 6th of 2018 unsecured building again in 2019. Finally, the borough was at their last wit, I guess, and took action and filed a citation, or not a citation, but action to demolish the building. So question is, why do I bring this up? You're sitting there thinking, well, clearly we're better off if this person now takes care of this site and does something there. Things are going to be better than they have been in the past. We're concerned, and we don't think that's the case, because the proposed use, this medical office use, if you look at the site plan or the conceptual plan that was submitted, I believe in January, you'll see there's going to be significant work that needs to be done in connection with a parking lot. They're going to get rid of all the existing vegetation. They're going to have to do significant excavation that's going to further exacerbate the stormwater problem until the stormwater control mechanisms are put in. They need to dig significant utility ditches on the property. So there is significant work that has to be done. And our concern is, what if it's not? What if in the middle of this work, when things get started, we run into the same problem? And now we have a situation where the stormwater is worse. We have a safety condition because we have excavation, we have utility ditches, we have all the landscaping that exists at that property site now is gone because they've come and excavated and they haven't done what they said they were going to do. My point is, I'm not sure, and this is purely speculation, was this filed just to get the Allegheny County Court of Common Pleas to stay the current demolition action that's on file? Because it's been stayed, okay? It's not proceeding now because representations were made that this development was going to occur. Well, if it doesn't, we have a significant problem. There's a much less risky path for this applicant if they want to do something with this property and regain some of their economic loss. There's an existing structure, a residential structure, where they could go in and renovate that structure. They would not have to do the same damage to the vegetation. They would not have to do the excavation in connection with the parking lot. They could use the on-site sewage. There's an easy path that this borough could force this applicant to follow if they said, you know what, we're not willing to take the risk with you because of what you've done over the last 16 years and not done anything that you were supposed to do with that property. So we're going to say, no, we're not going to take it on faith that you're going to negotiate and get a sewer line arrangement put in place and that you're going to excavate 2,000 feet down the hillside of Rustic Ridge and put in a sewer line without disturbing the land and creating a landslide risk, because we all know that if a sewer line leaks or causes a problem, that creates a risk for a landslide. Okay, so there are a lot of risks associated with this property beyond just the impact to the neighborhood. You have an option. You can force the issue and say, do what you're zoned to do, eliminate this risk. If for some reason you feel, you know what, we don't have that option and we disagree that the applicant has met their standards and the applicant is not creating a danger by putting a commercial building in the middle of a neighborhood, then you, as your solicitor said, as a board, have the right under section 1803 to impose conditions to make sure that that risk doesn't occur. You could, and your solicitor knows this field and knows what he's doing, and all of you obviously have significant experience, but there are conditions that you could put in there to make sure that the construction is going to occur within a certain time period and touchstones and milestones that are met. Because if those milestones aren't met, you're going to know you're going to have the same problem, and that'll provide you a path to go into court and have that stay lifted for demolition. So I would urge you, if you don't believe what we are saying is correct, that you provide very detailed conditions in this approval, or require them to be put in a development agreement. For example, and I'll finish up, you could very easily ask for a bond to say that, you know what, if you don't get this done and we have to demo the building, well, that bond's going to cover our cost to demo it, because why should we have to chase you down for that money? Your bond should cover the cost of the parking lot. Your bond should cover the stormwater detention facility, because if he doesn't finish it, you got to go do something. You're not going to get him to do it. So please consider the conditions that you have the authority to impose in connection with any approval. Last point that I would make is, and this is just a point for potentially your zoning officer to take a look at, is my understanding that the side yard conditions, the side yard dimensions on this plan are 10 feet side yard dimensions. But when I look at the non-residential use area and bulk requirements table in your code, that's section 212 attachment 3, it says that the minimum side yard, and it footnotes it, if adjacent to residential use, it should be 20 feet. This plan showing 10 feet. They're already right up on their neighbors, as you can see from what the plans and the pictorial things that have been admitted. I would urge you, if you're going to do this, then do some things to protect the neighbors by landscaping conditions, more significant dimensions for the side yards, and a stringent development agreement. It's my understanding that the record, and I'm not 100% sure, will remain open, but I would request the opportunity to comment on the plans and documents that were submitted tonight that we did not have an opportunity to review, and also to submit additional opponent evidence until the record is closed.
Well, no, I mean, there was not an intention to continue it. I mean, we can do whatever we need to do tonight, but you know, this is the opportunity to present any testimony. I know you mentioned an appraisal, but we don't have it. We can't continue a hearing on forever and ever. We do have time limits. It is a question, and we talked before of does council need to vote tonight? No, you do not, similar to last month. We have options in terms of closing the public hearing this evening, but tabling the motion to consider the testimony and the comments in particular, and proposed conditions. I know Tim listed a couple that aren't in a staff report now, but that is a consideration as well. But as for continuing it for another night, this is the night for presentation of evidence.
Okay, that's all I have. Thank you.
Thank you, Mr. Mello. Caster? Esker? Okay, thank you.
Thank you. I would just like to leave you with the picture that's more correct than what Mr. Melo has described. He tells you that this building is in the middle of a residential neighborhood. He fails to recognize that to our west, there is a residential house, but that property is zoned to the same R4 as ours is. Nothing stops that property owner from doing all the various commercial and residential alternatives that are available to our property that are available to his. He also said we are surrounded. That is incorrect. Two of our sides were abutting the Catholic Church. The Catholic Church is not a residential use. We have residential across the street to the north of us on the other side of Wexford Bain, but the only residential houses are to our west as far as immediate adjacency. So please be aware of the drawings we've showed you previously. This is not a surrounded by residential. He also talks in regards to the health, safety, and welfare. But the health, safety, and welfare that he spoke to was that the residents don't like what they're going to see. I'm sorry, that's aesthetics. That is not health, safety, and welfare. And he failed to explain what health, safety, and welfare. Are we going to be dumping medicines? Are we going to be running illegal clinics? Are we going to be burning things in the backyard? No, none of those things. There is no health, safety, and welfare. There's definitely aesthetics, and the neighbors have expressed their concerns. But this property is zoned for R4. There are multiple uses for it. We have chosen this one, and we've demonstrated to you that we are compliant with the conditional use requirements for a medical office. Thank you.
Mr. Victor. At this time, we've come to the end of the presentation of evidence, the end of public comment and summation, closing arguments. We do have a motion on the agenda. I can get that, and we'll stay on the record for right now as we discuss the next steps. As I briefly went over, we have come to the end of the public hearing, so I would recommend that we close the public hearing first and foremost, and then discuss whether or not council wants to take action on motion 3 or table it for further consideration. And it would be on the agenda at the March 15th meeting, but we would not have the court reporter. That would give council some time. Right now, the conditions of approval are reflected in Mr. Phillips' zoning officer staff report dated January 6, 2023, as part of the consideration of what you've heard and suggestions that can be updated and provided to all of council. We do have the opportunity to further discuss this in executive session as quasi judicial deliberations, and can do so at the the March 1st work session. So that is your one option, or if you're ready to vote this evening, you are entitled to vote this evening. But first and foremost, I will ask for a motion to close the public hearing this evening. I have that from Mr. Malkin.
Second.
Move to.
I'm sorry.
Sure. Go ahead, say it, make it official.
But move to close the public hearing for conditional use application number CU 22-12-05.
Second.
Second.
Seconded by Mr. Mizlinski. All those in favor, please say aye.
Aye.
Any opposed, say no. Hearing none, the public hearing is closed. We'll stay on the record for the next motion or discussion. Rather than making a motion and then having a debate, I'll just open it to council. Does anybody have any thoughts about our next action? Or do you want to proceed with the motion as written?
Mr. Yonker, I think I would be in favor of tabling the motion tonight and having the discussion as you proposed as possible in executive.
Agreed. We've heard a lot tonight. I think we need to do that.
Right, and under the MPC, we do have 45 days in which to render a decision after the close of the public hearing. We will be within that time period if we consider it at the March 15th meeting. So everybody knows, as well as the applicant and other participants.
Given the multiple concerns and articulated, I would agree that we should defer it.
And no further discussions. Does anybody want to make a motion to postpone until the March 15th meeting, the motion on this conditional use application?
Mr. Solicitor, I move to postpone the, is it the vote? Is that what we're talking about?
The action.
Yeah, the action on conditional use application number CU-22-12-05 to the March 15th
Signature.
hearing.
Second.
Properly moved and seconded. Any debate or discussion? Hearing none. All those in favor, please say aye.
Aye.
Any opposed, say no. Motion carries. Thank you all for coming this evening. We will continue to deliberate in executive session and consider all the comments as well as the transcript that will be produced. And if you do need to discuss or have any discussions, the vestibule is open. It is a beautiful night outside as well, but we do have a number of other items to move on to on our stated agenda.
Mr. Yunker.
No, because we're moving on to the next number. Yeah.
I have the same
PA
concern.
American. What's up here?
That would be Westview.
Westview Water.
I believe it was 60 miles.
Yeah, Westview Water Authority. Yeah, you know, called Westview. They've grown. I mean, they have an intake valve at like Roosevelt Island or right off of Neville Island. So it's in the Ohio River. So nothing's coming up that way at all. Going the other way, but that's who would know or could answer it. Yeah.
It is a concern.
Well, they're a public authority, so they have meetings and they take public comment as well. Yes.
Okay, Mr. Yunker, could you summarize resolution number 1323-2023?
We're gonna close around.
Cardinal Ridge Townhouse Plan.
The yellow. Give me 1 second. Okay, yes. This is resolution number 1323 of 2023 as amended. It is a resolution of the Borough of Franklin Park, Allegheny County, Pennsylvania, granting preliminary and final subdivision and land development approval to RRG Franklin Park LLC for LPF 22-08-02 regarding the Cardinal Ridge Townhouse Plan located at 2570 Alden Drive with conditions. We had the meeting last month. The original version of this resolution was voted down after discussion with the applicant about removal of the two modifications. We reconsidered that and granted their ability to submit a new plan with those modifications removed. We have, as of February 1st, received the revised plans. So those have been presented. We have had comment letters going back and forth, so the resolution has been updated with those, maybe not the very last one. But Mr. Phillips also updated his staff report. And I'll just say at the start here, as you saw in Mr. Phillips' staff report, although this was presented as changing the modification and getting rid of the slope disturbances, I mean, there has been a significant change to the stormwater infrastructure here. So under the case law as to what the 90 days, happens, we've included in the staff report that the 90 days have started over again because of this submission. We have set it up for a potential vote tonight, but we did want to hear from the applicant as to what is proposed because it is different than we were expecting and does have a different component with respect to stormwater management, which has been a concern for the borough as well as the residents. And I would invite, if there are residents that want to come to the front, or perhaps if we can orient that a little bit to see if you guys could come, yeah. Sure, come on, there's room over here. You can swing a table around. Thank you, Mr. Victor. All right, Mr. Cosgrove, floor is yours. Although this is not a public hearing, we have invited the applicant to give a summary of these changes before action by council.
Thank you, Solicitor Yunker. You did a great job summarizing exactly where we are currently. I will say that, yes, the plan is slightly different, although it is in more conformance with the township's ordinances. So understood, it is different, but it is actually more conformity. As you all remember, this plan was before council last month, where a number of council members took issue with only took issue with our request for a modification from the amount of slope disturbance. Council graciously allowed us time to attempt to revise the plan to remove the need for such modification, which we have successfully done by moving the detention pond that was proposed underground to be an underground detention tank. Right here. In the same location as the detention pond, but now it's underground. This new detention pond, or excuse me, new detention tank has allowed us to come under the permitted amount of slope disturbance and ultimately withdraw our requests for a modification. And it also actually acts to address, I believe, Ms. Avon's concern regarding the sightliness of the previously proposed detention pond and her fear that children would play in the dry bed, which now no longer exists. So it helps to address a public comment that was a public concern that was addressed, as well as come in more conformity with your zoning ordinance. Steve, you want to pass it around? Plan so they can see it. I'm not sure if you have it in front of you, but we have copies here too, so you can see. Mr. Victor's also here. He can kind of explain it. There is a drawing in there that shows the new slope disturbance on the site and our conformity therewith. Along with the new detention tank plan, a revised stormwater manager report and a revised geotechnical report have been submitted to the borough and have been reviewed by the borough engineer. And this change to the underground tank will not affect the stormwater runoff design computations that we represented last meeting. So effectively, we just put it underground. We believe we have addressed all the borough engineer's remaining comments. I know we've been going back and forth. We did get a revised letter yesterday, which we have since addressed. I'm hoping Sean was able to review it as very minor comments regarding a narrative that was added, as well as a revision to the stormwater pre-development plan. We can go over those tonight. They're very minor. I don't think we need to have any more time to review. I have copies if we want to see it.
Yeah, I mean, that was part of the concern of the back and forth pretty quickly, not how we typically do things. As
Understood.
Steve knows, we'd like to go things over with a fine tooth comb for 20 days in advance. But I think we like to hear a little bit more about the underground facility because we do have some land developments that, I think somebody mentioned the fire hall has one in the parking lot, but it's not a public infrastructure. And it doesn't pick up the street and it doesn't pick up houses or anything like that. And it's not something, that the borough crew goes out to inspect or has much familiarity with. So there is
But it also has a detention pond behind.
Oh,
Yeah, it does.
belt and suspenders.
Yeah.
I would be surprised though if Sean Wingrove is not very qualified to go out and make inspections on an underground facility. I can tell you, we'd use these all the time on commercial developments. Just because we know that they take up less space and that the option for it on commercial was really valuable. And that's why when we were before you last month, immediately came to me, where was our problem with slopes? It's at the south end of the site.
Right.
These two colors were the colors that we were looking at to get modification from. And you were very clear, you did not want us to do that, and we were looking for other options. So we knew the option to that was to go to the underground facility. Now, why is an underground facility less impactful? We have to deal with a volume of water. And when we deal with it as an above, what we call it an above ground facility, a detention basin, it's not floating up in the sky, up in the air, but it is touching the ground, but we refer to that as an above ground facility. When you have an above ground facility, this is the size of it, but then the grading continues on up the hill and catches up slope. Or you have a dam with it and it continues down slope. So a detention facility, above ground facility like that, has a much bigger footprint than if we can go underground. And so what we did was we looked at that area and came to using the underground facility. We had our engineer do the sizing calculation for it into a series of large diameter pipes that are interconnected, and they are also have holes in them for purposes of infiltration. And so we backfill it all with gravel. And so the water that goes into the tanks and has an opportunity to infiltrate into the ground as we would with any detention facility. So we satisfy both the 2-year storm infiltration requirements and also up to the 100-year storm for stormwater management purposes. Again, by eliminating dam and reducing the footprint, we also were able to save these trees right in this area. Again, was a concern we gave on from last month that, you know, we're taking out too many trees. So it is a good means by which we can reduce that footprint, save trees, and then remove any fears that a above ground facility might have for children by making it all completely underground. It works the same way as the above ground in that the water from the street all flow from the inlets via pipes to a infiltration bed. So it's a cleaning spot, if you would, small bio retention facility here. From there, the water then goes into tanks. That water has the opportunity to flow into the rocks for infiltration. And then after it reaches above the 2-year storm, then that water is discharged at the same rates that we were talking about with a detention facility. So the mechanisms of control are identical. They're just underground as opposed to being above ground.
Discharge is still right there above that little offshoot of work.
The exact same location what we have where there's drainage way that we're connecting, discharging out into.
When is the timeline for the dispersion of the water once you've had a significant storm? How long does it take? Because Mrs. Johnson expressed concern about the fact that now her property is going to be continuously wet instead of only occasionally.
Yeah. Unfortunately, Mrs. Johnson has taken the words that I said and then sort of magnified it to make it really sound horrible. Instead of a rainfall that hits and within 10 or 20 minutes, the water has left our property and is running now downstream and then to her property and on out, it now is going to take an hour or 2 hours. It's not going to stretch itself out for days or weeks. That didn't happen with an above ground facility, and it doesn't happen with an in-ground facility. It's the same. It's literally hours in which it is discharged out over. It just doesn't come as a surge. It's stretched out. So again, her concerns are not realistic to what the water will do coming out of here. Yeah, yeah, and I should fall back on to Sean here, and that Lennon Smith has reviewed all of our stormwater calculations through the above ground facility. They did review the one for the in-tank facility. They came back with one comment yesterday. We responded to that, and that was just simply a mapping error. They had transposed two numbers. We changed those. That was it relative to stormwater. It wasn't any big questions like, oh my goodness, you're going to flood Mrs. Johnson or anybody downstream. No, we've never had that in the whole time. Our engineer has stated, and Sean has agreed that we have met and exceeded the standards for stormwater that is set by the borough.
Under a tight timeline. And I think we appreciate Sean jumping and we put him in a different posture for having to review things pretty quickly or so. And I wish, Gary Buchanan, our superintendent of public works, his mother passed away. He is not here. And I know this is intended to be a private facility, at least at the outset, but we are going to have connections from this public road. And if in the future, the owner isn't doing the work, we know DEP is going to start coming, looking at the borough and saying, how are you going to, maintain and operate this underground facility? And I do agree, as I said, usually, you've got a commercial structure, you got a giant parking lot, you've got a lot of, impervious surface, but you can sink a tank underneath that parking lot and put a couple manholes in and do some inspections. This one, is it going to be just grass on top and it's not concrete and? Mhm.
Max, if I may, just question regard, I haven't seen your standard SWOMA, but typically when the municipalities that I represent, we create distinct language in there saying, if at any reason the owner is not maintaining the facility, the borough has the right to go in and make whatever needed repairs are necessary. Those are something that obviously we would agree to.
Mhm.
Is that not typical in this
No,
borough? Or?
we are, it probably more so than others. Just a resident putting some impervious surface on the back is filling out an operation and maintenance agreement, gets recorded, gives us that right. I know other municipalities for other even just surface stormwater ponds will say, okay, and also put up an escrow, for us to be maintaining it in the future. I think those types of considerations come into play here with respect to this type of facility that we don't see on residential streets. I would say it's not forbidden in the SALDO or in the stormwater management ordinance or anything, but it is unusual to be presented here.
Understood, and I think it's precipitated by the denial of the prior
Yeah.
modification request.
Right.
So that's the conundrum we're kind of in, right? Is
Sure.
we understand you would maybe prefer it to be above, but in order to do that, we needed to have a slope modification request, granted, and it was not. So we now needed to do this to
Sure.
comply with your ordinance. So
And we got more trees saved up there, and we've got the, the
it's a better
interstate
view
buffer
for,
yard better,
better view for the neighbors. I
some
think it
consideration.
doesn't change the ultimate discharge from the basin.
Mhm.
The same numbers we represented last month are the same numbers now. As I said before, I don't want to speak for Sean, but the borough engineer has not offered any, concerns regarding the plan. So
Yeah, I
they're trying to make it work, but
I understand. Yeah, and we appreciate you working with us and
we
you
appreciate the
appreciate us
opportunity
giving
to-
you the
opportunity. absolutely.
chance. And like I say, with a 90-day time period, I don't think something like this doesn't take 90 days to review. We do have a planning commission meeting on the 21st, next Tuesday. If you get a review from them, and, obviously it's been changed from what was recommended because you had the modification.
But I would object to that because nothing that the planning commission recommended has changed because they in fact actually recommended approval of the modification.
But then the plan changed, so they haven't even seen or made a recommendation on this. And
But
that's what the time period is
What,
supposed to cover.
what would have changed in their mind from what we had previously presented to them? If they had recommended approval of the previous plan with the modification, and we have now brought the plan into more conformity with your
Right.
ordinances, what would have changed to make them change their mind at all?
I think at least in terms of exploring this type of facility, are there other conditions that they need to consider? Like you're talking about a beefed up operation and maintenance agreement, or perhaps an.
But that wouldn't be a
escrow account.
condition from planning commission. That would be something that the
Oh, no, that'd be
Borough-
something they can definitely recommend to us. I don't know, because we haven't.
But what would the
gone through
condition
with
of
it.
beefed up swim, like that would just be something that we would work out with you
Well,
after
at least we
approval?
could-
That wouldn't be something that the planning commission would ever be in charge of looking at or
They do.
considering.
Yeah, sure. I mean, they definitely would. I mean, in terms of all this, I mean, I think in terms of the timing here, and I'm not saying, at the March planning commission meeting, because you're already out of their sequence. They need 20 days in advance. I mean, Tim, what do they have on their agenda on the 21st? Is it just Farrell? Pavilion? That's been up several times.
I asked Sean, in your experience, have you dealt with underground detention ponds in this type, underground detention tanks, excuse me, in this type of environment or this type of plan?
John?
Yeah, I mean, we see them. It's certainly atypical for residential. Oftentimes the cheaper option is a detention basin because you have space. I mean, the ordinance doesn't prohibit an underground tank by any means, if that's your question. And as Max mentioned, we certainly see them frequently for non-residential applications.
I'm curious if in your experience, you've seen any type of conditions that would need to be imposed due to the fact that it's now underground rather than above ground, I guess would be the heart of the question I'd ask you.
Maybe that would be a decision for planning commission and council. I mean, ultimately, we reviewed it. Don't disagree with what was said before. We reviewed it for the technical provisions of the ordinance, meet rate and volume control. We do have a comment left for clarification of the geotech report. And as you mentioned, a typo, and as clarification, the typo, the numbers and the calculations are correct. And the information leading to it has a typo. So it doesn't materially change the punchline of the report. So those are what's left in the letter as far as technical comments for consideration.
Max, I'm just having a difficult time figuring out what type of condition you could even fathom planning commission coming back with on this.
I mean, that's why we have them and why they're separate and why they, have the expertise to go over these types of issues. So, and I do think, they might have, and probably react positively, because I know that wasn't a unanimous vote on those
Right.
modifications. That might go a lot further here with council if there's a unanimous recommendation that comes out of them. As I said it before, we have the resolution drafted in a positive sense that's been updated, that reflects, they were submitted February 1st. I mean, we haven't updated it with the two post submissions. So, and that's where I come from. I appreciate Sean going through and looking at it closely, but I know in terms of our standard process, we don't like getting things the day of the meeting. I don't like getting them 2 days in front of the meeting. We've been through that before, and to make sure that there isn't something that was missed, no, we're not taking the entire 90 days, but to get another set of eyes on it, whose job is to review plans, and that's all they do. And there's time in the schedule, at least in terms of our review periods. I just think that would make the most sense, but I don't vote. As I said, it's teed up for a vote one way or the other, or a referral to the planning commission on an expedited basis. Or you could do it on just the regular basis, say March, whatever their meeting is,
If I may, council members,
March 21st.
obviously you are in your right to do whatever you see fit. Last month, you explicitly told us that the reason that you were not going to approve the plan was because of the slope modification. We have removed that modification. Otherwise you acquiesce to everything else. The fact that nothing in terms of the calculations or numbers have changed from us moving it underground, and the fact that your engineer has no further comments that haven't been addressed, I don't see the reason why we need to slow this down. We have been to planning commission 4 times previously, in front of you guys twice. I mean, I understand where Max is coming from. I do, but I don't see a possible condition other than ones that the engineer would have already proposed, which he has not, that they are going to come up with that we are going to need to comply with. So I'd ask, rather than just jumping ahead and moving it to planning commission, because that's the easiest option. You asked us to come back and see if we could get rid of that modification. That was your only objection, which we have done. And now we're just asking for final approval, preliminary and final approval. So obviously you're within your right to do as you see fit, but that's kind of our position at this point. We've been here 6 months now, getting through this, meeting everything that has been asked of us, playing as nice in the sandbox as we can, addressing comments from the neighbors. So, I mean, we're just asking for a fair shot really here. I mean, if we have to go back, I get it, but I don't think that's necessary because again, planning commission recommended this, recommended the modification that we have since removed and come into more conformity with. So I don't see how they could have anything to say that would change what we are coming here in front of you tonight. So.
And I appreciate that, Mr. Gar. I've been in your position as well, and I understand, we're dealing with the periods that we are in terms of the review process.
And we will work with the solicitor's office to figure out if you need to change your SWOMA to better address an underground tank. We can work on that after approval. I don't necessarily see why or how planning commission would comment on possible changes to the SWOMA. That's not their duty. But again,
right,
I understand your position, but that's just not something that you will ever see a planning commission comment on is what should be included in a SWOMA.
Well, there's a first time for everything, particularly when they're looking at an underground tank. And yeah, I mean,
is
we
this really
also,
the first
you've
time?
been there 4 times, planning commission 4 times. I mean, Steve and I were there way before on the original 2 plans that went through, been to the Commonwealth Court. We were trying to go to the Supreme Court. So there's a lot of time invested in this, and to, make this change at the last minute, I want this to be as perfect as possible so that the residents, that everything has been looked at. And it's not the plan that was recommended by planning commission because it's been significantly changed. So that's all
I don't think it's been significantly changed. The layout of the plan, the number of units of the plan, everything has been changed. The only thing that has been changed is we are now in more conformity with something that they already recommended approval on. So
I think also, yes, we received Glenn Smith review number 6 yesterday. We responded to that. No, 7th yesterday, I'm sorry.
There was one before that one, after the
6th one we received, we submitted drawings February 1.
Right.
So it's not like Sean and Lennon Smith has been given drawings that deal with the whole stormwater today.
Right.
No, they got them 2 weeks ago,
Right.
as agreed upon by the township that we could submit
Right.
those documents by February 1 for him to have time. Then review.
right, but it changed. I mean, you proposed us that said we're going to get rid of the modification. So, okay, that's it. But then the structure changed. I mean, that's where I come from.
but
to say
also
it's
there's no
significant.
authority, first of all, to revert anything back to the planning commission. Your ordinance is very clear that all they have to do is review the plan. And once they make a recommendation and it's in front of you,
But they haven't reviewed this plan. That's the problem.
No, they have reviewed this plan. See, it's not a new plan. You are treating it as if it's a new plan and it is not. It is a revision to an existing plan that they have already reviewed. That is a very big distinction. Court cases across the Commonwealth have said that there's never been an established doctrine that you have to go back to planning commission if there was a revision in front of the governing body.
Yes.
There's no court case that
There are
authorizes that.
cases for significant, and yes, we can, is that if you added one more unit, is that significant? I mean, the way that stormwater is dealt with in the Commonwealth, we can take the risk on a deemed approval or go that way, but it's been my opinion that looking at that, this is significant enough to give the 90 days and council, it's 90 days for, when a revised plan has substantial changes, the clock starts. And we don't do that in, the day-to-day. We work with the developer. We get an extension of time if needed, but at the end of the day, this has not been looked at by the planning commission. That's all I can
So
say.
you're deeming this to be a new plan then? Is that correct?
No, I'm doing, this is a substantially revised plan. Yes.
But it's not a new plan.
No, you've not submitted a new one.
So then
the
where,
cases-
where in your ordinance requires a substantially revised plan, as you call it, to
Mhm.
go back to planning commission?
That's the case law and that says the 90 days start. So we can sit on it for 90 days, but that's no,
So-
why we even do that? And
Right,
then
I
it's
don't
even
know why you
later
do
because
it.
your 90 days start at the first planning commission meeting. So you can go 30 days from your submission. We get even more time. But and I understand, it's, if this came back and it was a detention facility like before that was just shrunken down, I would perhaps agree with you that that's not a significant change, but when you bury it and it's not
And
something
improve it.
that anybody uses,
We bury it and we improve it.
well, no improvement, you change it, you improve the
To more
slope
conformity.
disturbance, there's more trees, you're more conformance with that, but it's different.
Mr. Cosgrove, do you deny that we have the authority to send it back to the planning commission council?
No.
Okay, well then I move that we send this back to the planning commission.
I second.
I find that you have no authority, explicit authority to do that, but you can do what you please.
Okay. Well.
Well, this is unusual. We've made it
Right.
up. It's from last month of trying to work this through, so we're in uncharted territory, but.
Hello, everybody. Thank you. My name's Ethan Fellheimer. I'm the developer, the applicant. Grew up in Swickley. I guess we're just frustrated. And I'm frustrated because at every opportunity, and I know my lawyer says, this, but at every opportunity we tried to solve the problems. And nothing for nothing, but there was 120 apartments approved here before. The neighbors should be thrilled that we're building something, that we're trying to build something that fits in the context of the neighborhood. As we, certainly more than 120. I can read mine. Okay, sorry. So I've used this underground storage tank on 4 occasions. There is no delta between an above ground, which Miss Johnston was concerned about for safety reasons. We addressed it. We brought it down underground, which takes safety. You are not concerned?
That was Ms. Avon.
That was Miss Avon. I apologize for putting,
Yeah.
I apologize. Which makes it more safe. The rate of water is the same, if not better. It's the same as the above ground. So we've taken away the nuisance, the attractive nuisance from law school, if I remember correctly. The attractive nuisance of the bed, so that no child will play in it. We've put the thing underground. The retention tank does what it's supposed to do, which is release it at a specific rate, which EPA, NPDES, every known site person knows. So it's an accepted typical manner of solving it. And I disagree with Sean because I've used this in 4 residential units, developments. This is a done.
In Allegheny County?
Yeah, absolutely. 5135 Fifth Avenue. You want to go
City of
over to
Pittsburgh.
what's that?
The city of Pittsburgh?
Yes.
Huh?
5 townhomes. There is a underground path at the bottom of the driveway. 5135, please buy one. We'd love it.
Tied into the public street?
We have a pump going up. We have a pump going up. It's very typical. And this, I don't know. There's only one way. I can't draft engineering for the neighbors. I can only draft engineering per the code. And we have done everything per the code. And for you to, for the council to send it back just because it doesn't want to deal with it.
But that's not true.
No.
We're sending it back because it's not typical for us. It's not. We've never done it in a residential development. We haven't. So
I'm not trying to pick a fight with the
I
council.
know, and
I
we do appreciate how much you've cooperated. At least I do. I'll speak. for
I
myself.
appreciate that. Thank you. And it's also this. I know it's not your concern, but it's expensive. These guys are expensive. Sean is expensive. And every time you put it back, you just say, run the meter for no reason. For no reason. Run the meter. I mean, asked us to get rid of the modification, he got rid of it. I mean, it doesn't get better than that. So I would really ask that you guys consider what you're doing, because I've got to make plans. So I really would recommend or consider not delaying this in 6 or 9 months of planning,
And
which is what you're setting me up for, is what I feel like.
no, I mean, that's why I'm suggesting that we can put you on in advance. So you're not going until the March 21st meeting, and then you're in council at April. I think if this is as significant, I'm saying,
We can't make the plan commission meeting next.
Yes, you can.
I'm saying we
So-
could say that I'm offering you to go on the 21st of
We'll
February.
be back here at March.
So you'd be here March 15th, because
Yeah.
otherwise we put you March 21st, and we're in April or
Right.
so. So,
Yeah.
and I
We'd
understand, sir, I
appreciate-
don't know if you were here for the meeting last month, couldn't be here. So, yes, and I would suggest we have some of it on video. We're gonna start posting it, but yeah, reading the room is a good skill, and you know, the way the vote went on the modifications, we're trying to make this work, so.
And Max, I just want to make it clear, like, we appreciate you guys working with us. We hope you appreciate us working with
Yes.
you and addressing your comments and trying to get through this. And I would guess I'd be a little bit more sympathetic to sending it back to planning if there was some semblance of concern from your engineer, your trusted professional, and there hasn't been. He accepted our stormwater report within the 15 days. He hasn't asked for more time.
But he's looking at it from, does it meet the term of the ordinance for the release rate and everything else? The
Right.
long-term maintenance of how this is gonna be done is a planning question,
But
when
what
it falls to us eventually.
Yeah, but what's the standard then that you're gonna govern
That's
us
for
on?
them to ask you of what does the operation and maintenance schedule look like here? You know, can kids get into it? Cause you can pop off, the manhole. Are there grates blocking the inlet? Cause I know when I was a kid, I would have explored that,
So,
underground sewer.
so you would appreciate, I mean, do we need Tyson here to describe it? So you basically, I'm sorry, I was just,
Yeah,
Tyson is our stormwater engineer, right?
Mhm.
So is that like, you want an education
yes,
on this stuff?
yes.
Okay. Okay, can you, just so we are clear, because
Yeah.
we've been back and forth. Can
No,
you,
I don't think anything else, in respect to the modification down below, the number, the parking, the only focus would be
so can
what is
we,
an underground detention facility on a residential cul-de-sac street involve, do?
I just wanted to know, can we
Yeah.
ask for a list of questions that you guys, I mean, do you want just a full seminar on what this entails? Like, I don't know what you know, what you don't know, what you want to know.
Well, I can tell you, we have never had an underground detention facility picking up from a street, how they're done. When they are done on a commercial or a land development plan, maybe it's inspected during infrastructure. And we've had, so on the golf course, I mean, we reviewed trying to do storm bricks, to do an underground detention facility there. It became way too costly, way too much maintenance. I mean, that's council's experience with underground on a property we own, everything else. I'm interested, and if there are, stories of other successes about how that works from a public inspection and operation and maintenance, because it is unusual. And I think, if there is some recommendations that come out of it, or at
isn't
least we
there-
get a vote that says we recommend this plan.
But how would
that
the
has
planning
been
commission
provided.
vote no? What basis, what standard what could they employ? There is a presumption in your ordinance that this is an acceptable means of stormwater detention because you've allowed it. So I don't know.
Well,
if
we never allowed it.
there's,
for this
it's
type of
not,
plan.
it's
We've
not
allowed it
prohibited. It's
on
not
a-
prohibited, which is an inference that it's
Yeah.
permitted.
Which we can confirm by the 21st, because yes, on the first we got this was the first time it showed, and yes, Sean did his review.
So I understand, but I'm just questioning. We give the presentation. They say whatever they say, but then if, what justification would they have to deny it, is my question back to you.
Well, they don't deny or grant, they
Recommend denial,
recommend. So
recommend
that's
denial.
our-
Fair
We
enough,
want
recommend
them
denial.
to get familiar, with this and know what is being approved.
Well, could
because
that happen? I mean, we can have a seminar anytime. I mean, it doesn't have to happen through the approval process, considering there's nothing that's conditioned upon us having to prove anything to be approved. So if you want, we could get approval and then we could have a meeting with the borough and whoever you want to educate on what this will entail.
I mean, I
I
come
don't see
back
how
to-
this
I'm-
plays
I'm a
out in the
creature
approval
of
process.
Procedure and process and making sure that we aren't getting in deemed approval issues, that we're advertising things correctly, that we're doing things correctly. And when we change the process, by trying to work with it, my default is to go back, okay. Planning Commission looks at everything that has been approved. They should look at this. They should give a recommendation. It's probably going to be positive. I don't know what would happen in terms of it. They should understand what this is and put it to council so we don't have to go through everything else, that we can say, okay, we can answer to the residents that, look, the plan changed 14 days before we voted. It has been, reviewed. It is unusual, but it does pass not only the technical calculations, but in terms of the, what the borough will be expected to do with this, you can have. And maybe it's something to consider. I know Gary does not typically attend those. I'm not sure if he'll be back from bereavement leave, or at least somebody from Public Works to sit in on the Planning Commission meeting might be something to consider as well.
If you send us back to Planning Commission, can we please get a letter from you or Tim just stating that we are here
Yes.
at the behest of the council, that the 21-day or whatever the timeline is for submissions have been waived by the borough,
Right.
that we can't get anything in terms of, well, we get there and they tell us, oh, we haven't had time to review it. So if I could ask for that, at least,
Mhm.
that would be much appreciated. Tim, I don't know if that would be in your purview, if you need that from Max.
I think we could work together, and that would be, yes, we are waiving or going out of order. Make it as streamlined as possible so you don't go off on tangents would be the way. We would
Streamlined to
handle it.
the sense of just education on the
Yeah.
stormwater?
Yes, I mean,
Okay.
as you say, everything else, but when the modification changed, they can see how much trees are left behind and what this will entail, both on the underground and, I mean, I see it, the bio retention. I mean, is that essentially a rain garden that you have right there? Okay, so we have rain gardens in the parks, but not in a residential subdivision just yet, and that's good. That's going green. But cool off. Mhm.
This was designed to be in compliance more in.
And I don't want to, we took it up at 10 o'clock, we want to all go home, I get it. But again, if we're limiting what planning commission is discussing to us putting it underground, which is permitted, to which there are no specific standards, to which the engineer has found no issues with our flow, I appreciate we can educate them, but
Mhm.
why does it have to
They
be through
could
the
put
approval process?
Conditions,
What
I
is-
mean, even if, if there is something that comes up as part of that discussion. Yeah, I mean, I don't know what it could be because I don't sit with them, but in terms of, is there different, requirements that you put for gating it, not a fence or anything that's there, but the outfall structure, does it have a trash rack on it or is it open? I don't know.
Manhole lid is going to be as heavy as the manhole of the existing sanitary sewer manhole. No kid is going to be able to do that without a pry bar. I've tried to lift it myself, but for a man, I can't do it. So it's a safe, it's a child-proof, yeah. And if some kid wants to crawl up with any one of your slugs or bites, they're going to do it. But again, they say, I think
Yeah, I don't know. Yeah.
I appreciate your pursuit of knowledge, Max. I do, but is this really the course of, is this really the
Pursuit of
proper?
knowledge, and it's following the process that,
But
you know,
well,
planning
it's-
commission did not see this plan. That's what I come back to. And that's why we have them.
I think we
They-
have a motion and a second,
Yes.
and we need to vote.
Can I add just if you're gonna motion to send it back to planning, can you just condition it upon that the solicitor
Review
and the
of
town,
the-
the borough will work together to inform planning commission as to the intent of that meeting.
So moved.
Reasonable request.
Yeah.
Yes.
Amended motion?
And
Forget the name.
Yes.
Assuming they make recommendation.
Yeah.
Reasonable to assume that we would be back in.
Next
March.
month,
Yes.
yes.
Yeah.
That's our,
That would
that's
be
our
the
goal.
idea.
Yeah. Mrs. Crummer, would you do a specific roll call?
Let's formulate the motion to,
Oh, sure, sure.
oh, no.
Sure,
Yeah.
yes.
Let's say how much people know. There seems to be this misconception that number one, we as a community said no. And I don't think, at least I've never stood up here and said, no, you can't do it. And if you reflect on my opening statement this evening, I said, I don't deny anyone the right to purchase and build. I mean, this is why we are here in America. This is our right. My only concern, and I don't like to think that I'm exaggerating. I haven't walked in here and said, my entire yard is gonna be flooded. I don't have that perception of that's what my home. My whole concern is there is water being run. I know that there's water running through my yard from the top. I get that. And maybe I don't understand it. You know, but I look at that natural dry time that we have now with the water coming down my yard. So for one to say I've like morphed this into some huge image of flood and disaster devastation or whatnot, I don't think I have. I just don't, even with our ordinance, how a storm water management plan allows for storm water to run into a down. My concern. I don't. But our ordinance says it's not. Whether it's developed or not, our ordinance states that I quoted earlier. But if it's what you have to do, I'm just concerned about it. I mean, with wetland, like I stated, you do have the infestation of pests and things. Something I didn't even think about until I started doing a little bit more. Yeah, and I talked about our property, you don't know 100% if I don't know 100% if my land is going to be damp or wet, but the possibility exists. I need. Put a cup underneath. Turn on every hour for a little bit. I mean, it's still going to be there unless it's naturally dry out. So whether I truly understand what they're saying or not, possibility, it's not my forte. I'll teach your kids to read, but as far as this is concerned, it's not necessarily my forte. But to assume that I hyperbolize, that I'm against this, I just need to know that my problem, that's the only thing I've ever been. I do not want something that is going to happen. And I just happen to be the downstream problem.
Good evening. I'm Bernie Avon. I live at 2604 Lorik Lane. And just wanted to ask a couple questions here tonight at council. The first thing is, I kind of want to put this on the record. I don't know if it's been put on the record with the council, I think we brought it up in one of the planning commission meetings, but I just wanted everybody to know, if you don't know already, that my property, the Woodworth property next to me, and the Hollands down at the end of the lane, we all have private wells. And we are concerned about the construction activities, and now we're making changes here with the underground facility. I don't really know if that's going to affect it too much, but I think it'd be wise that we get a baseline test done on all our wells, so that if there is damage to the wells, that we can have some recompense from the developer. The developer has reached out via an organization, I think in McKeesport, forget the name of the company. He's offered to do that baseline testing for us, which is a good thing. And I just wanted to put that on record and wanted to say thank you publicly for that. So that's the first thing, but it is a concern. Redrilling a well is a major expense. I know the Hollands have expressed interest in trying to get city water brought down. Whether we have those discussions privately with the developer is another matter. It won't be discussed here tonight. But if we do have a situation where our wells have degraded either in quantity or quality, it is a major concern. And I just wanted that to be on the record here tonight. The other question I have is, it deals with the de minimis language. And I know that the reason we were here tonight was because the slope disturbances, the two modifications to the saldo, I'm not using variance, I learned from last time. Those two material modifications were rejected. So they made a plan change here. And I just want to, I agree that we should follow process. Being from the engineering profession, it's always a good idea to follow your process, because something could be missed. And I appreciate that you guys are trying to be thorough. I'm sorry, Mr. Developer, that it's expensive, but that's not what we're talking about. We're trying to make sure that this is done right. So I encourage you guys to vote that way. I think following and sticking to your process is a good thing. Back to the de minimis language, I wanted to ask this question. The roadway that was granted, almost said it, the modification to the saldo to allow the developer to put a road in 175 feet from Lower Lane was granted via de minimis. My question is, it was at least portrayed that way.
No. A de minimis is a variance concept that, it doesn't even require a variance, and it's such a small change. Yeah, this is a modification. Yeah,
Is 25 feet?
it hasn't been granted officially just
Okay.
yet because it's being reconsidered, but it is the only modification that's being requested due to the physical constraints of how wide that property is.
Right. But okay, so so you guys are saying then is 25 feet. I don't know, Sean, is this your area? Is 25 feet considered a de minimis?
No, it's not a de minimis concept or question.
I'm sorry.
Yeah,
I'm sorry.
That lives in zoning. right?
Yes.
That lives in zoning world. We're in modification.
Yeah.
Yeah, that's a record. too.
Be good to be, as far as possible, but that's what a modification is there for those physical hardships and considerations.
So it was recommended because it's considered as a hardship for them?
Yes.
Is hardship related to just the ordinance, or are we saying financial here? Because I thought it should just be.
The
Okay,
hardship, or the ordinance, it's a requirement that in general, 200 feet from another street should be allowed, but that can't be met because of the physical limitations. Modification be requested, and if it's supported, great.
Okay, well, that's all I had tonight, so thank you.
Thank you. I think to restate the motion has been amended and is on the table. The motion is to refer the revised plans to Planning Commission at their February 21st meeting, waiving the 20-day requirement for them to be added to the agenda with the direction that only the removed modification and the stormwater facility be reviewed by Planning Commission. And that, I'll even say, regardless of a recommendation or a vote, that this otherwise will be on council's agenda for action at the March 15th regular meeting. I think that helps you as well. If they say that they need more time or others, that we do want to constrain it to just one meeting. And if they say we don't want to make a recommendation, it will come to council without one, but we will have it on the March 15th regular meeting. That would be the motion.
Yes.
You want to do?
And I'm
roll call
seconding
vote?
it.
Yes.
Yes. Do a roll call.
It was seconded by Brian.
A question afterwards, after the vote?
Okay.
Or should I ask it now? Doesn't matter.
Does it apply to the motion?
Does it apply? Debate or discussion?
No, it's more of things that, there's some things to ask for the planning commission.
Or instructions?
Okay.
Okay, just before we vote, just a couple of questions or recommendations. So for planning commission, and there's a lot of engineers on there, so you're gonna get some questions. First of all, like what? Oh, yeah, sure.
I appreciate this. I really do, Mr. Pallad, because we know we got confused sometimes at planning commission. So
That's fine. This might be very technical on this stuff. Is your stormwater engineer planning on being
Yes.
being there?
well, we
It might-
have to make sure he's available, but we will try to get somebody with knowledge of.
Might be very helpful.
Do it
So
electronically if need be too.
of
Yeah, that's
course.
true.
What is, so some of the questions that I have are, what is the cost of this SWMF or whatever the acronym is, this underground tank? What's the cost of it? And well, there's,
Yeah, substantially more expensive.
I understand that, but the borough is on the hook for this after you're long
No,
gone.
no, it's gonna be a
We
private.
potentially are at the end if, the property owner isn't maintaining it and they
Yeah,
tell
but
us we
then
have
you
to
would
dig it
come
up.
back
and
for
put it
costs.
back in.
Yeah,
What's
you,
that?
you would come back to us for costs of that. You would never be on the hook for that.
Yeah, but if you become judgment proof,
It's just a general question. You want me to
Keep
keep going or just?
do it.
should I
It's two steps.
You wanna get to the-
That's fine.
Yeah, we're gonna get it later at
Yeah.
one point.
That's fine. Like, what's the lifespan of these things? You know, just general information about this. How is it maintained? Is it like a car? Do you have regular maintenance?
Pumps.
Pumps? And you said you're putting grass above it, so is there like some depth?
How deep will it be?
Yeah, you're putting grass above it, right? That, I heard you mention that.
Yeah.
Is there like, what's the depth? I mean, just curious.
It's shown on the construction drawing, but we can't-
Yeah,
We'll answer that.
Can you
Yeah.
drive on it?
Oh, yeah.
trees.
I mean, you got an access road going right to it.
Can you drive on it?
Otherwise, it's structurally capable of holding a vehicle.
Right.
Yeah.
That's above it.
Sorry, Mr. Pallad, were you done?
Yeah, and then this gravel road right here, is that to maintain it or what's?
Just to maintain?
Yeah,
That's just for periodic.
okay, so. like
So we
here-
could probably, what would probably come up and we can discuss this, but I would imagine we'd gate that. Yeah, like we were gonna do with the
Like the
emergency
other one,
access road, we could gate that.
This with the chains or whatever you
Yeah.
you mentioned
Okay.
before. Mhm.
Yeah,
that
that's
way-
all I had. I mean, those are some of the questions that if I were asking, that's
Good. Those are good.
what I'd be curious about.
I
As a member of
appreciate
the
that.
planning commission.
Yes, I know.
As a
yes.
member of the planning
You're one of
commission,
all
yeah.
people who spoil it here.
Yeah,
So,
there's other engineers there that I'm sure they'll have very technical questions, but for me, these would be my concerns in terms of setting up like a bonding operating agreement, et cetera, whatever.
Mr. Malcolm, did you have?
I do not. I'm good. Thank you. Thank you. If we could roll
Okay.
call.
Mrs. Crummer, one more time.
I think we all know the motion. We won't repeat it.
Yeah, we're good.
This is for
Yes
This
or
is
no?
just referring it to the
To the
planning
planning
commission on
commission.
20.
Yeah, I agree.
Yes.
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 We'll
Thank
get a
you.
letter out. Request.
Yeah. 3 months in a row. You guys are lucky.
Right?
Okay.
Lot to vote on in the March meeting.
Moving right along, could we have motion 5, please?
Move council authorize the payment of the bills which have been reviewed and approved since the last meeting.
Second,
Any discussion? All in favor?
Aye.
Opposed? Motion carried. Mr. Yunker, could you summarize that ordinance number 674-2023?
Certainly, this is ordinance number 674 of 2023. It is an ordinance of the Borough of Franklin Park, Allegheny County, Pennsylvania, amending chapter 159, property maintenance in the code of the Borough of Franklin Park to adopt the 2018 edition of the International Property Maintenance Code, regulating and governing the conditions and maintenance of all property, buildings, and structures by providing the standards for supplied utilities and facilities and other physical things and conditions essential to ensure that structures are safe, sanitary, and fit for occupation and use, and the condemnation of buildings and structures unfit for human occupancy and use, and the demolition of such existing structures in the Borough of Franklin Park, providing for the issuance of permits and collection of fees therefore, repealing all ordinances and parts of the ordinances in conflict therewith, and establishing severability and effective date provisions.
Move to enact ordinance number 674-2023, amending chapter 159 entitled Property Maintenance in the Code of the Borough of Franklin Park to adopt the 2018 edition of the International Property Maintenance Code, regulating and governing the conditions and maintenance of all property, buildings, and structures.
Second.
Well,
Any discussion? All in favor?
Aye.
Opposed? Motion carried. Mr. Yunker, summarize ordinance number 675-2023, please.
Certainly, this is ordinance number 675 of 2023. It is an ordinance of the Borough of Franklin Park, Allegheny County, Pennsylvania, amending chapter 122 fire prevention in the code of the Borough of Franklin Park to adopt the 2018 edition of the International Fire Code, providing for the issuance of permits and collection of fees therefore, creating a new Article 3 entitled Fireworks in accordance with Act 74 of 2022, repealing all other ordinances and parts of the ordinances in conflict therewith, and establishing severability and effective date provisions. This has been properly advertised for action this evening, correct, Ms. Crummer? Just like the last.
Move to enact ordinance number 675-2023, amending chapter 122 fire prevention in the code of the Borough of Franklin Park to adopt the 2018 edition of the International Fire Code, providing for the issuance of permits and collection of fees therefore, and creating a new Article 3 entitled Fireworks in accordance with Act 74 of 2022.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carried.
Move the set aside agreement in the amended amount of $654,570 for the Deerfield Estates Plan Phase 1 be reduced by $54,600, leaving a balance of $599,970 in accordance with the letter from Lennon Smith Solar Ray Engineering Incorporated dated February 1st, 2023.
Second.
Any discussion?
yeah, I have, and actually, and I have brought up some issue and with this Deerfield and developer, and couple of times regarding like they dig a hole or like cut the street open and to start some project, and maybe that was not listed on the like the job that they did to finish, but what they did really and bring up a lot of issues, and for us who always and go past that place. And so is there anything that we can do just because and this look like they can do whatever they want, and we don't have any way to just regulate or monitor and what they can do. And which make me and also many residents of my community and frustrated because so many people have talked to me regarding that they develop company and doesn't care about what they have done. And even they damage something, but they don't want to fix. And it looks like we still let them like be reduced by 54,600. And we cannot take that something that they did really bad into the consideration. So is there any way that we can do something?
That's a PennDOT road. Have any of the residents contacted PennDOT to let them know about the issue?
No, okay, the residents mentioned something to me just because this was done by the developer.
Right,
Sure it was
on
the
a
developer.
PennDOT road. It's a state road.
Or was
So
it,
they had to get a permit from PennDOT.
or was it a utility? Was it
They
gas
just
company,
cut the
Columbia
street
Gas?
open and they just pour some I would say concrete inside.
It looks like.
And
Yeah. Well, I mean, it might have been at the developer's request, but it could have been a utility.
When it's not 45 degrees and rising temperatures.
Yeah.
so my question is always like, why this kind of thing happened?
Because it's a PennDOT road.
Well, yeah, this is.
No, we can, PennDOT, yeah, definitely, they wouldn't let the developer to fix it, but why that happened? And it's just like beyond my understanding.
You mean why they cut through the road?
Yeah,
Well, this is a project that Franklin Park residents have been asking for years, that it get done as quickly as possible, repaving of Nicholson Road. So PennDOT couldn't wait for the developer to decide when they wanted to pave Nicholson Road. In fact, they moved it up to the first part of their project schedule for us because we asked for it specifically. So PennDOT couldn't control when the developer was going to do a utility cut across the road. They simply knew that we asked them to pave Nicholson Road as fast as they possibly could. And that's exactly what they did for us.
but for us, for the residents live in that area, and we kind of feel like the developer and just did something to the road and which caused a lot of trouble to us and drive on that road. So that is a concern that has been shared by many residents. It's not only from me, it's from many residents in living that area.
I will contact PennDOT tomorrow and make sure they are aware we consider that to be an issue. I know they don't pave in February, so I don't think they can pave it now, but I will let them know that our residents have a major concern about Nicholson Road.
Thank you, Dr. Lee. We do understand your concerns. We still need to vote on this.
Yeah, sure.
All in favor?
Aye.
Aye.
Opposed? Motion carries.
Move to authorize the borough secretary to advertise for bids for trucking services.
Second.
Any discussion? All in favor?
Aye.
Aye.
Opposed? Motion carries. Mr. Yunker, would you summarize resolution number 1324-2023?
Certainly, this is resolution number 1324 of 2023. It is a resolution of the Borough Council of the Borough of Franklin Park, Allegheny County, Pennsylvania, declaring certain personal property of the borough as surplus and authorizing its disposition by electronic auction sale.
Move to adopt resolution number 1324-2023, declaring a 2013 Ford Interceptor SUV, last four digits of VIN number R2263 as surplus personal property, declaring the estimated fair market value over $2,000, authorizing the sale and disposition of electronic sale on Monday, March 20, 2023 at 12 p.m. prevailing local time on Municipid online auction, municipid.com, and directing the secretary to advertise this same.
Second.
Any discussion?
No.
All in favor?
Aye.
Opposed? Motion carries.
Move to appoint Elizabeth Basco to the Environmental Advisory Council to fill the unexpired term of Cassandra Miller Butterworth, which term will expire December 31st, 2025.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carried.
Move to hire Mary E. Card as park groundskeeper effective February 27, 2023 at a rate of $25.20 per hour.
Second.
Any discussion? All in favor?
Aye.
Motion passed.
Move to purchase a Komatsu compact hydraulic excavator with accessories from Anderson Equipment of Bridgeville, Pennsylvania at a cost of $123,995 through Sourcewell National Contract Number 032119-KOM.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carries.
Move to purchase a 60-month/3,000-hour dealer extended warranty for the Komatsu compact hydraulic excavator from Anderson Equipment of Bridgeville, Pennsylvania at a cost of $3,658.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carries.
Move to grant a 90-day extension for the signing of the development agreement for the Tweco Car Wash to be located at 2620 Nicholson Road.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carries.
Move to authorize the execution of the sanitary sewer line easement agreement between the borough and James D. Oliver or successors in interest for property located at 1576 Pano Lane in a form acceptable to the solicitor.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carried.
Move to authorize the borough manager to enter into the agreement of sale in a form acceptable to the borough solicitor for the purchase of the vacant real property located at McAney Road and identified in Allegheny County block and lot number 822-F-319.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carries.
Move to authorize advertising for bids for the curb and gutter replacement program for the 2024 road paving program.
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carried. Comments from Mr. Ebner, manager.
None.
Mr. Yunker. Mayor O'Keefe.
None.
Mr. Powell.
None.
Mr. Malkin.
None.
Mr. Mislinski.
None, Mr. President.
Dr. Lee.
No.
Mr. Schwartzmeyer.
No further comments.
Junior Councilperson Avon DiGiacomo. Mr. Wingrove. And
No, sir, nothing.
all right. Lieutenant. Okay, Mr. Phillips. Please do.
You know, this is gonna live on in perpetuity, Tim.
Four score. Four score. Mr. Broward. Mrs. Crane. All right. And Andy, any hands raised on the Zoom? Are you there?
He said no.
None? I hear none.
Yeah, he did not.
Doesn't look like there's any. Okay. Motion to adjourn.
So moved.
Second, all in favor?
Aye.
We're out of here.
Well, not quite.
You're out of